charges in a case in which we know that we will not be able to prevail because the law does not support the charges. And still, and yet, a loving, promising young man is dead. His death leaves us with a wound in our community, but that is small in comparison to the wound that his family is suffering from. Communities have been torn apart by the trauma yet again, and the life of a police officer has been changed forever as well. If the law does not allow us to file criminal charges in this case, what can we do as policymakers, prosecutors, society, community, to keep a death like Amir's from happening again? First, we need to interrogate whether no-knock warrants are ever really needed. There are inherent risks for everyone involved, including civilians and officers. Cities like St. Paul and even some states have stopped using them, and it hasn't hurt public safety. Yesterday, Mayor Frey issued another no-knock policy, which appears stronger than the previous one. Now this policy needs to be actually enforced and obeyed. Then maybe Minneapolis can get the results like St. Paul, which hasn't used a no-knock warrant since 2016 with no harm to public safety. Second, Congress must pass the George Floyd Justice and Policing Act. I don't mean someday, I mean now. We need state and local actions as well, including enacting the rest of the recommendations of the working group to deadly force encounters that Commissioner Harrington and I released more than 2 years ago with the inspiration and advice from County Attorney Freeman. Third, Minneapolis leaders need to talk about putting it into in-custody deaths this way, but we need to get serious about doing it. The problems involving policing and communities of color in Minneapolis are long-standing and everyone knows it, yet it feels like nothing ever is done about it. Finally, as prosecutors, we need to continue to hold offenders accountable and uphold the law and uphold standards of justice. The fact is, as I've said before, we'll uphold the principle that no one is above the law and no one's beneath it either. And with that, I think we're prepared to, unless you want to make some more remarks.
Amen.
Thank you very much.
All right. Our first question comes from Omar Jimenez from CNN. Do you plan to speak with the Locke family at all? If so, what is your message to them after what they may see as a disappointing result here?
The Attorney General and I spoke with the Locke family at length this morning. They are fine and decent people who are full of grief. And we expressed our personal sympathies and empathies with the family. They, like us, are very frustrated with no-knock warrants. They, like us, believe that if a no-knock warrant hadn't been used, Amir Locke might well be here today. Other than that, I think it'd be inappropriate to comment other than we had a long conversation, and I know they will continue the effort and the work that Keith has talked about, trying to make our society safer and to remedy some of the racial inequities that exist in our criminal justice system.
All right. Our second question is from Lou Ragoose at Care 11. Thank you for providing additional detail in the frequently asked questions. My question for Mr. Freeman and Mr. Ellison after reading these reports, would you agree that officers have pretty wide-ranging authority to kill during these kinds of warrants to an extent that a large segment of the population is uncomfortable with?
Well, what we would say is that the area of no-knock warrants needs reform. I'm glad that the city of Minneapolis mayor issued a revised policy that is stricter than the last one. But I would agree that there's very broad discretionary latitude. I will say that it calls for reform, and I think it's appropriate for a community to engage to have a policy that's going to preserve life for everyone involved. I will add this. No-knock warrants aren't particularly safe for officers either. They have attendant risks on both sides, civilians and officers. So it's appropriate to investigate and to come up with policy that works.
Our next question is from Esme Murphy from WCCO. Can you address who the independent expert is and what access did he have to investigative files and other resources? And how often have you done something like this, hired an independent analyst?
Our independent expert was retired Captain Jack Ryan, a police expert in deadly force. He had access to all of the evidence we did, including the body-worn cameras, the statements by the police officers, the search warrant. He did a thorough, complete, and independent review of this. Jack Ryan has been involved in cases in Minnesota before, and at least several of those cases, he's been quite critical of the Minneapolis Police Department and actions of the police officers. But in this case, he agreed with the conclusions that Keith and I and our staffs arrived at independently, that the law and the facts did not support a prosecution of Officer Hennepin in this case.
All right. Our next question is from Steve Karnowski from the AP. Did Amir Locke have a carry permit as his family has said?
That issue it wasn't relevant to our analysis. His family has said that, but because it didn't really matter, he was in a home, he was in lawful possession of the firearm. He was not a person who couldn't have a firearm. So, that issue, while I know it was raised in the press, ultimately doesn't impact the decision in this case.
Our next question is from Andy Mannix from the Star Tribune. Does the body footage for Hennepin support the claims that Locke was pointing at him? When will we see the rest of the footage?
To answer the latter part first, the body-worn camera video will all be up on the Bureau of Criminal Apprehension's website today, if it's not up already. The body-worn camera footage for Hennepin and the other officers show the gun that Amir Locke was holding at the time he was shot. It shows that Amir Locke was holding it by the butt of the gun in a shooting position, although his finger was not on the trigger. That gun was pointed directly at Officer Hennepin. During the body-worn camera, it seemed to dip down a bit and then come back up. And that's confirmed by both the officer statements and the body-worn camera, which you can see later today.
If I may add, the term pointing might imply a level of intentionality that we don't know whether Amir Locke had or not. We don't know what was on his mind. It could have been an inadvertent moment. We don't know if he was pointing it, but the video does indicate it was pointed in the direction of Officer Hennepin.
Good clarification.
Our next question is from John Collins with NPR. Why not let jurors decide whether the evidence shows that the officer's actions were, quote, reasonable?
And as a prosecutor, you have an ethical responsibility to not bring charges when the law and the evidence show that you can't prevail. We have the burden. We have to prove the case beyond a reasonable doubt. And it is our conclusion that we cannot prove this case beyond a reasonable doubt that the officer's actions were unreasonable. This is an important justice matter because you don't want to put anybody on trial for a case simply to meet public demand. It has to be a ethical consideration based on prosecutorial ethics, and that's what we're abiding by.
I've received a question that says, what department was Jack Ryan with? Was he with MPD?
I do not believe Jack Ryan was ever with MPD. I do not recall exactly which departments he may have been at. That, again, is on the Bureau of Criminal Apprehension website. His vitae is there. I just don't recall that.
Our next question is from Scott at Minnesota News Network. even though you acknowledge the law and facts don't support charges in this case, what is your message to Minneapolis community members, particularly those of color, who see this decision as another example of police getting away with murder?
I say, first of all, we understand how you feel. This is a heartbreaking situation. We have a situation here where a young man is dead. There's no evidence that he was ever a suspect or that he ever intentionally tried to harm the officer. And yet we have a very unsatisfactory situation here. But we have to abide what the legal standards are. The fact is that the struggle goes on. We can make reform in the area of criminal justice reform. We can make reform in the area of no-knock warrants, police procedure. We can continue. There's still a viable civil matter here. There are a number of things community can and should do to carry forward. And so this is not the time for people to feel like there's no hope. There is. People should carry forward and continue to try to make the system one we can all be proud of.
All right. The next question is again from John Collins, as we haven't received any others from different news outlets. Does Statute 609.066 need to be revised?
That's a very complex question. We asked police officers if shots are fired to go towards the shots when the rest of us as civilians go away from it. Because we asked police officers to take steps to protect us, they have rights under statutes like 609.066 to use deadly force when they are confronted in a situation where a reasonable police officer who is not part of that situation at the time believes that there's a plausible threat and that a use of deadly force is required. That's based not only in the Minnesota statute, but the federal constitution and a whole series of federal case laws. What I think we can try to do that perhaps will accomplish some of the reforms that Keith and I are both talking about and want to occur is to make sure that officers are less often in situations in which they're confronted and they think they have to use deadly force, and to make sure that officers are thoroughly and completely trained to use deadly force as only the last resort. I think we have work to do in both of those areas.
Let's see. We have one more question. It looks like from Lou Regoose at Care 11. Under the apparent circumstance of Amir Locke waking up with a gun and potentially believing this was a home invasion, what would have it taken for charges to be appropriate in this case?
You know, I do appreciate Lou's question, and I understand why he's asking it. It simply is beyond the scope of our mission. It would require us to speculate, and I don't think that is the right thing to do at this time. I think this is probably a good time to wrap up.
Let me just say in conclusion, I agree. It looks like we've answered the questions. I really support what Keith said in his opening. We've got lots of work to do in the criminal justice system to make it safer. And this death is a tragedy and was not necessary. But we are honored bound under our ethical rules only to charge cases in which there's sufficient admissible evidence to prove it beyond a reasonable doubt, and we believe it's there. To charge a case like this would simply be wrong. And I really appreciate the courage and the commitment of the Attorney General and his staff and mine, buttressed by the opinion of Captain Ryan. This is not a fun part of our job. We try to make it as professional as we can, but our hearts still go out to the family, and we need to make a situation where these kinds of situations don't exist.
Yeah, thank you, Mike, and let me thank again the family. Meeting with the family today was something that is essential to do. They have the right to transparency. They have the right to understand why. And I just want to say I can't think of a more dignified family under the circumstances that they're in, and I just hope the community continues to rally around them and continues to demand that we have a fairer, better system. So with that, I think that's probably it.
Thank you.